All right, this is 25M2303. We've got Mr. Grimes present with counsel Ms. Deere, and we've got Ms. Welsh with the prosecution.
Jack, you calling me Mr. Grimes again for the
Okay.
final time.
Well, Mr. Grimes, that's your name that we've got in the case, and so I'm going to refer to you as Mr. Grimes.
Excuse me.
Okay. Mr. Grimes, go ahead and come on up. I need you to appear. Okay, well, then I'm going to consider that a failure to appear. And so you can either come on up into the air. No, you can come on up and take a seat at the defense table, or I'm going to consider that you're failing to appear. So it's up to you.
Arrest and under threat
Okay,
of arrest.
all right, well, go ahead and take a seat, sir. All right, we've got Mr. Grimes present. We're scheduled here today for a status hearing. And so Mr. Grimes had indicated that maybe he wished to proceed without counsel. Is that what you still wish to do, or do you wish to still have counsel, sir?
That is no counsel. She has not provided counsel.
All right, well, then let's finish the questions that we were talking about last time. And so, Mr. Grimes, it's my understanding that you wish to proceed pro se, represent yourself in this case. Is that still
I cannot
accurate?
represent myself. I'm a living man. I
Okay.
cannot represent.
Well, I'm a
living
living man too, and, I'm
I
appearing
can
here in
prove for
court.
myself through Jesus Christ, but I cannot
Okay.
represent myself.
All right. So I don't know what you want. Do you want counsel, or do you want to represent yourself?
I can have standby counsel, but there's no standby counsel. Counsel has not done any counsel. So how far can that help?
I don't know what you mean by standby counsel. Are you saying advisory
Sixth
counsel?
Amendment states that I have the
Mr.
right
Grimes,
to counsel, not
stop.
representation. Nobody can act in my behalf as I am. I am a living man who is free.
All right, Mr. Grimes, you keep interrupting me. I'm going to give you your first warning here today. If you keep interrupting me, I'm going to hold you in contempt of court. We talked about this last time. And so that's your first warning. Okay. And so do you wish to represent yourself, or do you wish to have counsel appointed?
I cannot represent myself.
Okay. So do you want to
That is a
main,
dichotomy.
so do you want to maintain your representation with Ms. Deere then?
I do not need someone to represent me.
Okay.
I cannot represent myself. She cannot represent me either. That's a dichotomy.
You appear to be playing games, Mr. Grimes, and so the court,
No games.
stop interrupting. The
comprehend.
court, stop. That's your second warning, Mr. Grimes. You seem to be playing games with the court where you're saying that you want to represent yourself, but then that you don't want to represent yourself. You indicate that you potentially want counsel, but you don't want to say that you want Ms. Deere or appointed counsel. Which do you want? Do you want to represent yourself, or do you want counsel?
How can I represent myself?
A lot of people choose to represent themselves.
That's because a lot of people aren't reading the law books to comprehend that language.
Okay.
The legalese is a very dangerous language to the American people.
It's a pretty simple question right now, Mr. Grimes.
I cannot represent myself. I'm already
Okay.
here.
Then I'll keep Ms. Deere on the case. And so we need to schedule this matter then for trial. And so today I'm going to enter a not guilty plea on behalf of Mr. Grimes and set the matter for
Put on
trial.
record that you practice law from a bench.
All right, I'm going to schedule it for a jury trial.
Will that be a jury of my peers, citizens of the state, or will that be?
It will be.
persons?
It will be, sir. All right, either our speedy trial deadline would be January 6th of 2027. Any objection to that calculation, Ms. Deere?
No, Judge.
Any objection to that calculation from the prosecution?
No, Your Honor.
Okay. I could do trial on this matter. What about November 5th through the 6th? Would those dates work for you, Ms. Deere?
Yes, Judge, I would ask to not do those dates because I do have 2 trials already set, so could we pick another date? I just don't want to be.
Yeah, what about November 9th through the 10th? That's a Monday and a Tuesday.
I can do that.
Okay, does that work for the prosecution?
Yes, it works.
All right, and so we're going to schedule our trial on November 9th through the 10th. We start at 8:30 a.m. on those days, Mr. Grimes. I can do a pretrial readiness conference on Wednesday, November 4th at 3:30 p.m. Does that work for the parties? Does that work for Ms. Welch?
Yes, it does.
Does that work for you, Ms. Deere?
Yes, Judge.
All right, and so Mr. Grimes, the pretrial readiness conference is going to be at 3:30 p.m. You need to appear. I'm going to require that you appear in person for the pretrial readiness conference.
Sure.
If you don't appear in person, then I'm going to know you're not coming to your trial dates. I'll vacate your trial dates. I'll consider that a waiver of your right to speedy
I
trial.
can't be here for the trial. You never asked me if that date would work.
Why can't you be here for the
I'm
trial
gonna be on-
dates?
I'm gonna be on night shift out of town in New Mexico working. I
On,
can't just take off. I have to provide for my family. I have bills to pay.
okay,
The majority of people that I've heard today, they have actual crimes that have been committed.
Mr.
Got
Grimes,
false allegations. I mean, people wrecking cars and almost injuring people and stuff like that. They're actually producing felonies and such.
what if I did Thursday, November the 12th through November the
I'll be off
13th?
until after Christmas.
I can't schedule it out after Christmas. That's outside of speed.
I have to provide for my family. I have a wife and a son to provide for.
Well, Mr. Grimes, it's a circumstance where the case has
You
been
have bills to
pending.
pay. I have bills to
Mr. Grimes, stop interrupting the court. Final warning. Stop interrupting the court. Okay. And so, Mr. Grimes, the case has been pending for so long, we have to do something substantive. And so I'm scheduling it for trial. I have to schedule trial before January the 6th. And so it's going to be before January the 6th. And so these are the dates that are available to the court. And so you're going to have to make arrangements to be available for them.
Can't.
I can work on other dates. I could do November 12th through the 13th. I could also do December 3rd through the 4th. So does December 3rd through the 4th work better?
Best I can hope for you,
So those dates are potentially better.
potentially.
Okay, let's do that then. So let's reschedule it for, let me white this out here, okay? All right, let's do if the parties are available. Does that work for you, Ms. Deere?
It does.
Okay, does that work for the prosecution?
Yes, it does.
What I would note is that we're gonna have kind of a weird schedule those dates because my staff need to be able to attend the holiday party. So it'd be 8:30 a.m. till 2:00 p.m. on Thursday and then all day on Friday. And so, okay, so the trial date is December 3rd through the 4th at 8:30 a.m. The pretrial readiness conference would then be on, I mean, I could do the day before Thanksgiving, or I could do, yeah, I kind of have to because the next available date wouldn't be until November 4th, which is way in advance of trial. So let's do a WebEx pretrial readiness conference on November 25th at 3:30 p.m. And I would authorize, since it's the day before Thanksgiving, Mr. Grimes to appear remotely for that hearing. Would that work for you, Ms. Deere?
Yes, Judge, I would likely also appear.
Yeah, I'd authorize you to appear remotely as well. Mr. Grimes, does that work for a remote appearance for you that day?
Remote?
Mm-hmm.
Yes.
Okay. Does that work for the prosecution?
Yes, it does.
Okay. Mr. Grimes, I will remind you that the same rules regarding court decorum apply when you're on the phone or in person. And so just remember that. But we can go ahead and do November 25th at 3:30 p.m. I can do a motions deadline of August the 7th.
I have till August 7th to challenge everything, correct?
Yeah, and you can talk to Ms. Deere about that.
Alright.
The motions would need to come from Ms. Deere.
I'll be pushing my own motions.
We'll talk to Ms. Deere about that. The response deadline would be August 21st.
August 21st is how long I have, correct?
Present yourself. And so
I
you've,
did not.
okay,
I did not say that.
you
You entered that
did.
for me.
you
Put on the
indicated,
record that he's entered
Mr.
that
Mr. Grimes,
speaking for me.
Mr. Grimes, earlier you indicated when we talked that you can't represent
I
yourself.
can
And so
counsel myself.
stop interrupting the court.
I'm not trying to be rude.
You are being rude, sir.
I'm not trying to.
Okay, well then try harder. Okay. And so I'm not going to play these games regarding it. You indicated that you can't represent yourself. And so I was willing to potentially let you represent yourself, Mr. Grimes, but you wouldn't let me get through any of the questions to do that. And so you've indicated that you can't represent yourself. You previously indicated that you wanted counsel. And so you're going to have counsel on this case. Motions need to come from counsel. And so I'm going to schedule an evidentiary motions hearing just in case we need one. The response deadline is August 21st. The evidentiary motions hearing will be on September the 8th at 3:00 p.m. if the parties are available. That's a Tuesday. Would that work for you, Ms. Deere?
Yes, Judge.
Does that work for you, Mr. Grimes?
What? I
For
can't hear
motions
you.
hearing? A motions hearing.
Motions hearing?
You'd need to be here in person for that.
Trying to get one?
You'd get a motions hearing, September 8th at
When
3.
what?
September 8th at 3. Does that work for you, sir?
And what type of motion hearing?
I don't know. No motions have been filed yet.
So I have till September.
That's just the date of the hearing, sir. I'm trying to find out if you're available. Are you or
I
are you
have till
not?
August 27th, correct, to get motions in.
August 7th?
August 7th to get any motions in.
Correct.
Then September,
8th would be the hearing on any motions at 3.
can I appear WebEx?
No.
I can't take time off. I'm the only CDL driver that my company has.
Half the people.
Josh Lindell on behalf of Mr. Chiarelli, who appears with us in custody.
All right, we are scheduled for, so I set this for a pretrial conference. The first time we set it for the pretrial conference, there was a whole bunch of other things ended up happening, so I didn't get my checklist together. So I want to make sure that we have everything set, okay? So you're scheduled for trial on July 21st. Are the people announcing ready?
We are, Your Honor.
Mr. Lindell, on behalf of the defendant, are you ready to proceed?
Yes, Your Honor. Mr. Chiarelli has indicated he would prefer to go pro se at this time. He does not wish to waive his speedy rights, but he does wish to continue pro se.
Mr. Chiarelli.
Yes, Your Honor.
I mean, can you get me an Argrio advisement?
Yes.
It is obviously your right to go pro se, but I will tell you that you don't have any legal training. This is not like what you see on TV. This is actually really hard work.
I understand. I understand this very, very much so. I don't actually want to do this at all. I have extreme concerns with my breakdown in communication with my attorney, and my want is not to go pro se, but my want is to be actually capable in assisting in my own defense.
What
And
does that mean?
Communication. I have had no actual visits from my attorney leading up to trial. The first time that I've seen my attorney in the last 2 months has been for less than 20 minutes in preparation for trial. Our actual legal strategy that we talked about for less than 20 minutes. As far as a capable client who is capable and knows his own rights and has been cleared as somebody who is not only by the courts found competent and able to assist in his own defense. If my attorney cannot strategize with me and is not capable of finding the time to go over strategy with me of what we are going to do in trial, then I would rather blunder through trial by myself.
Okay, listen,
As much as I am
first say-
capable of, because
Okay.
my freedom is on the line here.
Okay,
And I know,
okay, I recognize that, Mr. Chiarelli. I will tell you that, as I'm sure you can imagine, Mr. Lindell has multiple cases and many, many other clients. And so I know that you've indicated that he hasn't, that he's seen you for 20 minutes. Based on Mr. Lindell and what he did at your motions hearing, that I'm confident that he's familiar with the facts of your case. He's familiar with what your arguments are, and he's familiar with how to proceed in trial. But it's not simply the facts that matter when you go to trial. What matters is all of the other legal aspects of the case that make it difficult for someone who is pro se to know what they're doing. You
absolutely.
understand? And the reason I'm saying this to you is because, just one small example is when you're selecting a jury is not just a matter of picking a bunch of people out of a hat. There's a process to it. There's strategies to it. And these are things that you don't know how to do. And Mr. Lindell is familiar with the way the process works.
100%. I understand this, and I respect this part of the legal process that I am not currently empowered in my education to the standard that Mr. Lindell is. Like I said, this is not my chief want, but I have a issue where, just recently, Mr. Lindell and I are trying to communicate where he's trying to communicate with Mr. Aziz and I, where Mr. Aziz is trying to communicate about a possible plea agreement between me, Mr. Aziz, and Mr. Lindell. And even the communication back and forth to us, I can't get Mr. Lindell to actually communicate my words to Mr. Aziz and I. He wants to argue with me rather than, he gets angry with me rather than actually communicate. When I say, could you go tell him this? No, I'm angry with you and you're gonna talk to, and it's just like, okay, well then can we talk to Mr. Aziz and you and I together? No, that makes no sense to Mr. Lindell.
I think Mr. Chiarelli, upon that further record, is requesting a burger root hearing rather than to proceed pro se.
I can't do that though, because I cannot, unless we can do that within the frame of speedy trial.
No one, we can't,
Right.
and his speedy runs like soon.
And we've already run over Speedy. Honestly, we've already
No, we didn't
extended,
run over
well, because Speedy was supposed to be, I think, the 7th originally. We've already, we've already extended past Speedy twice, actually, when we told it the first time, and then we went to the 21st when it was supposed to be the 11th originally. So, from a defendant's standpoint, who might not know the legal process, but knows his rights very well from the National Assembly, a federal, state, and sovereign citizen right. I know my rights. Those are things that I know very, my standpoint, I can't. I love a burger hearing, but this is why I pressed it after preliminary hearing and tried to get in front of a burger court from that point, because from the point of preliminary hearing on, I've asked for burger hearings.
Well,
I couldn't get in front of them. I just can't.
Based on what you're saying anyway, it's unlikely that anyone would, any of the other judicial officers would appoint you another attorney
Right.
based on the record that you've made today. But before accepting your decision to waive representation by an attorney and allowing you to proceed without an attorney, I need to advise you of the effect and the consequence of your decisions, okay?
Yes, ma'am.
But I'm gonna ask you some questions to which I'm gonna record your responses, and then I will have you sign this document, okay?
Okay.
Now, hold on one second. A criminally accused enjoys the constitutional right of self-representation under the United States Constitution, Colorado Constitution, and the Colorado Constitution. The right of self-representation is personal to the defendant and may not be abridged by compelling the defendant to accept a lawyer when he or she wishes to represent him or herself, and that's under People versus Romero. 694 P. 2nd, 1256 Colorado, 1985. Now, Mr. Chiarelli, do you read, write, and understand the English language?
I do.
Do you understand that you have the right to be represented by counsel throughout these proceedings?
Yes, Your Honor, I do.
Do you understand that if you cannot afford an attorney, that one will be provided to you free of charge if you qualify for the appointment of state-funded counsel under JDF 0404?
I understand the basis, not the statute.
You understand that if you can't afford an attorney, you would be entitled to an attorney, which is part of the reason why you have the public defender's office representing you.
Okay, so like I said, I understand the basis of it's
Yeah,
possible
okay.
representation.
Do you understand that I will appoint counsel to you if you want an attorney, but you have an attorney and you just don't want that attorney, so you know that.
So this question, like I said, this is coming about from maybe something that I misunderstood, because the actual conversation that I had with Mr. Lindell was, he was talking to me about a possible plea agreement that Mr. Aziz had offered him. And Mr. Lindell got frustrated with me, and I said, well, could I possibly just speak to Mr. Aziz about this? Because maybe I'm not communicating right with you. And he said, well, shit, you just want to represent yourself then? And I said,
Okay, I don't know, Mr. Aziz, are you here by yourself
Yes,
for the rest of the afternoon?
I am anticipating that, yes.
I don't, look, Mr. Chiarelli, the long and short of it is, it sounds like what you're saying is that Mr. Lindell was getting frustrated with you, and as a result, you
that-
feel like.
That's how it got communicated that I wanted
Okay.
to represent myself, because I wasn't telling him I want to
But you
represent
don't
myself.
want to represent yourself.
I wasn't necessarily communicating that. I was communicating that I would like to talk to possibly him and Mr. Aziz. And then it got to, well, I'm just going to tell the judge you want to represent yourself. And I was like, okay, I guess that's where we're at then. I don't know.
Your Honor, if Mr. Lindell and I can coordinate, maybe outside a docket, having a further conversation, and we can add on if something changes.
Are you available this afternoon to have a conversation with Mr. Aziz? Are you available?
I mean, other than being in here.
I know, but I'm talking about like, it's 1:20.
Yes, I have two cases at 1:30. I believe it's two cases at 1:30 and that.
Well, I meant like
Yeah,
3 o'clock.
as soon as that's done.
As soon as it's done. Are you here for the rest of the afternoon by,
Yes.
we'll be done by 3.
Okay.
Okay?
Sure.
Why don't we continue to go through the pretrial conference stuff? And then,
Your Honor, could we maybe take up pretrial next Monday?
I am in trial.
Okay.
I'm in a
I'm out
homicide
until
trial
next
for the
week.
next 2 weeks.
Understood.
So, and then, I have a different judicial officer here for your trial, so I'm not gonna be the one presiding over your trial. So what I'm gonna do is, this is what I'm gonna do. You guys can talk about this a little bit later, and if you want to keep Mr. Lindell, great. If you don't, I'm gonna go ahead and I'm gonna go over the advisement with you just in case you decide that you don't want him. Now, if you want any other attorney that you can hire on your own, that'll be fine, but keep in consideration that no attorney will be ready to go on July 21st. All right?
Right.
You should also let him know.
Now, so you understand that, so I still have to ask you these questions so I can go through this advisement, okay? Do you understand that I will appoint counsel if you want an attorney to represent you, if you qualify for the appointment of state-funded counsel, which you have, all right? So you understand that?
Yes.
Okay. What are the these are the charges against you. You have, one charge of aggravated robbery. Or excuse me, hold on one second. We have one charge of criminal attempt to commit aggravated robbery pursuant to, that's a class 4 felony. And that's under 18-4302 subsection 1B and 18-2101. For a class 4 felony, you're facing between 2 years and 6 years in the Department of Corrections with the mandatory period of parole of 3 years, okay? And then, hold on one second. 2 years to 6 years DOC and 3 years parole. And then you're facing count 2, which is second-degree assault. For that, you're also facing between 2 years and 6 years in the Department of Corrections with mandatory period of parole of 3 years. You're facing, actually, you have 3 counts of second-degree assault, so you're facing that for all 3 of those as well. You also have 1 count of criminal attempt to commit assault in the second degree. That's a class 5 felony. You're facing between 1 year and 3 years in the Department of Corrections and mandatory period of parole of 2 years. And then you have 2 counts of menacing, which are both class 5 felonies, and you're facing between 1 year and 3 years in the Department of Corrections and 2-year mandatory period of parole. Is there any aggravation here?
Yes.
I will say that the defendant is subject to the 2 prior felony rule. He was pending a felony out of Broomfield at the time of arrest, so he would be enhanced.
So he would be looking at, on the class 4, he'd be looking from 4 to 12?
Yes, Your Honor.
So on all of those count 4s, on all of those class 4 felonies, which are the attempt to commit aggravated robbery, the 3 counts of second-degree assault, you're actually facing between 4 years and 12 years in the Department of Corrections, all right? With the mandatory period of parole of 3 years. On the class 5 felony, you're facing between 2 years and 6 years with the mandatory period parole of 2 years. And those are for counts 5, attempted second-degree assault, and the 2 counts of menacing, all right? Do you understand that?
I understand.
Clarify just on those assault 2 charges, they have the different sentencing scheme. It's 5 to 16 instead of 4 to 12. Well, that's the presumptive range.
5 to 16, not the 4 to. It's not midway through the presumptive?
I think because they're officer assaults, it's 4 to 12.
So there are,
Charge to assault cause injury with a deadly weapon.
so all 3 of these are, oh no, so Larry Smith is not an officer, but Grunther and Rembert are officers.
Yes, they testify.
So on count 2, he'd be facing between 5 to 16?
Yes.
And then on count 3, 4 to 12, count 4, 4 to 12, count 5, you're facing between 2 to 6, count 6, 2 to 6,
I think it'd be 1 to 6, Your Honor. For count 5.
count 5, oh, the assault, attempted assault, 1 to 6,
Yes, Your Honor.
and then the 2 menacings.
1 to 6 on both.
That's a jury laughing before they. All right, and then, excuse me. Do you understand that?
I
Those
do,
charges
yes.
against you? So you see that you're facing up to 16 years on that count 2, and then the rest of them,
That's
I've
right.
indicated what you're facing, right?
Mhm.
Okay. Do you have any legal training?
No, Your Honor, I don't, not in this.
How far did you get in school?
I have a college degree, neuroscience.
To waive counsel and represent yourself.
Like I said, I wasn't necessarily, I was just asking if maybe I could speak to Mr. Aziz for a moment, that's all.
Which you
I
will do.
wasn't trying to necessarily say that I wanted to cut my counsel or represent myself fully. I was just thinking that maybe I could communicate directly what I was having a hard time communicating indirectly to Mr. Lindell if I had just a moment to speak to Mr. Aziz with Mr. Lindell or directly to between the two or three of us, you know? That's what my suggestion was when I think Mr. Lindell got a little frustrated with me and wrote, okay, so you just want to go pro se. I wasn't trying to suggest that I'll just go pro se, but if I have to, then so be it, was, you know, my line of the reasoning. So I'm not, you know, that wasn't what I was necessarily trying to do, but if I have to, then I will, yes.
Okay.
I just,
So the question that I asked you though is, do you wish to consult with the public defender before you make a decision as to whether or not to waive counsel and represent yourself?
I don't really wish to waive counsel or represent myself, honestly.
Okay. All right. So then what I'm gonna do is I'm gonna pause this right now. I'm gonna hold on to this paperwork. You guys can talk later and what, we'll meet on, I'll have, a different judicial officer, advise you on Friday at 8:30, okay?
Okay,
If you reach an agreement, great. You'll be in front of Judge Bland probably on, Friday.
okay,
So she'll make the decision as to whether or not you have waived your right to counsel and how you plan to move forward.
okay.
All right?
All right, thank you.